Well, howdy there, stranger. I'm Jordy.
And I'm Brad.
And welcome back to Beers with Queers, the true crime podcast where I research a case, and Brad here, and potentially you guys.
Don't know a damn thing about it. Except this week, I do. That's right, you're getting back-to-back Brad episodes. And the case this week is probably one of the most important cases in queer history so far.
All right, well, I'm ready to hear this. This is going to be interesting. I don't think we have much to add this week other than the fact that we are halfway through September, which means we are halfway to Halloween.
Actually, I'm going to jump in there. This Wednesday, we actually go every year. We do a short film for the Knoxville Horror Film Festival. You go and you draw a random number from a hat, and then they have so many categories up on the board, and depending on your number, that determines which category or which genre, or there'll be something like, I know one year we did car exploitation film. And so it basically picks your topic, and then you have a week to write, film, and edit a video. And then right before Halloween, they actually show them at a local drive-in movie theater as part of the Knoxville Horror Film Festival. And we've won it a couple of years. We've also got disqualified a couple of years. We won't go into that. It was good reasons, trust me.
Yeah, that is coming up this Wednesday. And as you can tell, my mind is a jumbled mess because I don't know when anything's happening anymore.
And I'm telling you, that's a big thing, because once we get that category, we have to write, film, and produce this thing in a week. And it is very hectic, very fun. All our friends are on board for it now. We've literally filmed in a maximum security prison. Hot Rods was filmed at the old Brushy Mountain maximum security prison. It's really fun, really cool. And the main thing I like about it is at the end of it, we have this little snippet with all of our friends in it. We usually kind of go for like funny horror, but it's just kind of like this time capsule. We can look back every year and look at our achievements. And plus, each year when they show it at the film festival at the drive-in movie theater, we treat it as a movie premiere. So we all dress up, all the friends come down. It's really cool for them to be able to see themselves like on the big screen, and to hear other people cheering and everything when the video's playing. So it's kind of one of the highlights for me for each year. Whether we win or not, it's always really fun, really hectic, and just an all-around good time.
Yeah, it's a very fun time, and it's a very good way to kind of usher in the Halloween season because you know how we love our horror movies around here. And so it's always a fun time, always an adventure, honestly, especially with some of the stuff we've come up with. And actually, the closer we get to it, I'll probably post links to the ones we've posted and done in the past. Of course, Hot Rods. And then there's one called Just the Tip of the Axe.
Just the Tip of the Axe won, most likely to cause protest.
Yeah, and we've won that a few times, so we'll
And
post the link.
they actually made that category up for our very first film, which we probably will not put up.
Yeah, that one can remain one of the lost ones. It was our first.
But we did win that year with that film. But it was an interesting one.
So yeah, we have that to look forward to, and we also got to start thinking of some spooky stuff to do with the podcast, of course. You know, I usually like to do like Halloween themed episodes. Like last year we did like Halloween in the Castro. And I think we did one that was trick or treat murder. And the year before that, we did a queer hauntings episode. And so, kind of some stuff in the pipeline, trying to think of what we can do this year. Always try to elevate it as much as we can. But honestly, I'm just excited. You know what they say, Halloween is gay Christmas. And so all the gays are going to be going crazy. And I feel like it's going to be a really good Halloween year. So I'm excited to get into it. I'm also terrified the fact that it's already almost Halloween, but that is neither here nor there. But with all that out of the way, yeah, Brad is back, back, back again, 2 weeks in a row. I know you guys love it. We love to see it. I love to see it, and I'm excited to see what Casey has for us because, like always, it's my turn to see if I do or don't know a damn thing about it. So I think without further ado,
Let's kick it off. One phone call, a report of a gun that didn't exist, and minutes later, two men are marched out of their private home in Houston and booked for a crime that in Texas only existed if you were queer. That arrest would pry open a locked door and force a country to look inside, ultimately becoming a cornerstone leading to many of the rights queer individuals have today. This is the story of Lawrence versus Texas, and it begins with John Geddes Lawrence. He was 55, a medical technologist, quiet, self-contained. He rented a modest apartment in northeast Harris County outside Houston city limits. He liked routine. He worked his shifts, he came home, he cooked simple meals, and he kept his place neat. He wasn't a movement leader. He wasn't on a microphone at rallies. He was just an ordinary gay man living an ordinary life in a state that turned that life into a misdemeanor. Back in 1973, Texas had a line in the penal code that said sex acts between two people of the same sex were illegal. The statute used clinical language, deviant sexual intercourse, to describe what it banned. It left straight couples alone. It singled out queer people, and it made that difference the point of it. On paper, it was just a Class C misdemeanor, a fine, no jail time, and on paper, it looked pretty minor. But the statute did more than write a ticket. It marked people, specifically queer people. It said their private lives were offenses. It put a shadow over jobs, families, and basic dignity. And it gave police a tool that they could reach for whenever they wanted to remind people where the lines really were.
and I think that's what most of those, on the books laws are really about is very much it's about to keep minorities and people they consider lesser than in line so they don't get any funny ideas like, wanting equal rights or something like that, because that's a crazy concept, especially, I'm sure, in 1970s Texas.
The country had been here before. In the summer of 1986, a case out of Georgia made its way to the highest court, Bowers versus Hardwick. A man named Michael Hardwick had been arrested in his own bedroom after police entered on a technical warrant. The charge? Sodomy. He challenged the law, arguing that the Constitution's guarantee of liberty protected the privacy of his home, but the court disagreed. By a vote of 5-4, the justices ruled that the states had the authority to criminalize same-sex intimacy. Justice Byron White, writing for the majority, declared that the Constitution did not confer a fundamental right to engage in homosexual conduct. He dismissed the argument as, in his words, at best, facetious. That decision didn't just close a door, it slammed it shut. It told queer people across America that the highest court saw no constitutional shield around their most private acts. It meant that sodomy laws, many written decades earlier, were not relics of the forgotten past. They were alive and they were enforceable and sanctioned by the court itself. After Bowers, the patchwork of laws stayed in place. In some states, the statutes gathered dust, used rarely, if at all. But in others, they became tools, pulled out when police, prosecutors, or judges wanted leverage. Arrests might be infrequent, but the threat was constant. It was enough to deny custody to family court, to block adoptions, to fire employees. The mere existence of these laws was a weapon, even when not enforced. By the late 1990s, 13 states still had sodomy laws on the books. 4 of them, Texas, Kansas, Oklahoma, and Missouri, aimed only at same-sex couples. The message was unmistakable. Straight couples could do as they pleased. Gay couples could not. It was discrimination carved directly into the statute. It was a constant reminder that privacy was fragile, that the state could cross the threshold and turn intimacy into a crime at any time.
Yeah, because it could be, on the outside, by the 1990s, yeah, the gay rights movement has happened and stuff like that. And it's like, yeah, you guys have all these rights and stuff like that, but don't push it too far because we still have these decades old laws on the books and we can technically, within our rights, to use them at any time. So you have rights and you're free, but also not really. So, yeah, it's just like a looming threat they can have where it's like, don't push it too far or we're going to make an example out of you.
Houston by then was a city split with the usual lines: race, class, and freeways. But it was also stitched together by a large, visible queer community. There were bars that had been around for decades, activists who knew the courts and the city council chambers, churches that opened their doors, and churches that slammed them. The AIDS crisis had already ripped through the neighborhood and left scars in its wake. People there knew what it meant to show up for each other. John's circle was small. Friends knew him as generous, with a lift or a couch. He had neighbors who minded their business and others who didn't. On weeknights, just the single guy, illuminated by the light from the TV. But on weekends, sometimes he had some company. One of those people was Robert Eubanks. He'd known John for years, on and off. He also was tied to a younger man, Tyron Garner. Tyron was 31, black, easy smile, easy charm. He and Robert also had a history, complicated and not always stable. Tyron didn't have a car that week, and rides were favors, and favors meant plans that changed at the very last minute. The three of them wound up together one late summer night in 1998. Not downtown, not in a bar, they were just in John's apartment. Robert Eubanks was a man with ties to both John Lawrence and Tyron Garner. He had been involved with Tyron off and on, and the relationship wasn't steady, and it wasn't always healthy. At some point, tensions rose that night. Jealousy. Eubanks didn't like how comfortable Tyron seemed with John. He didn't like being sidelined, and he felt replaced. This is where the details blur depending on who's telling the story, but what is clear is this. Eubanks storms out. He leaves the apartment seething, and instead of just cooling off, he picks up the phone. It's around 10:45 p.m. when he dials 911. He tells dispatchers that a man is going crazy with a gun inside of John's apartment. Those words matter. They're a trigger. Houston, just like anywhere else in America, trains officers to respond fast and heavy when a firearm is mentioned. A weapons disturbance isn't a call you ignore. Eubanks knows this. He knows what those words will do, whether he intends to get John and Tyron in trouble or he's just lashing out in anger. The result is the same. He frames the situation in the most volatile way possible. Eubanks gives an address, John's apartment, and the dispatcher logs it. The urgency of the call suggests that lives are at risk. Within minutes, sheriff's deputies are rolling. Sirens low, lights sweeping through the dark streets in a working-class neighborhood northeast of Houston. Deputy Joseph Quinn is the first to arrive. 2 more follow close behind. They step out, hands near holsters. When it's a weapons disturbance, it means that the door you're about to go through isn't just a door, it's a possible danger. So they don't wait for a warrant. They don't pause for consent. They push inside. And since this was a weapons disturbance, they were fully justified in doing so. The reports differ on what they see. Deputies will later swear under oath that John and Tyrone are together in the bedroom, engaged in what the statute called deviant sexual intercourse. They'll say that they saw it plainly, enough to make an arrest at least. John will deny it. Tyrone will too. They insist nothing like that happened in that moment, not when deputies came through, but their voices won't be the first ones entered into the record. The official story begins with law enforcement.
And I'm going to go ahead and say I believe John and Tyrone over the cops. I fully see it in my head.
Especially if, there's a lot of drama going on. That's not a very romantic time.
No, and I very much see it in my head. They get called to an apartment for a crazy man going crazy with a gun. They go full guns blazing, going in, hot and heavy. And what are they going to do? Go back and be like, no, it was just, we look like idiots because this was a false alarm when just broke into these people's house. Or are you going to be like, well, we can still make an arrest because obviously we think it's two gay guys. All we got to do is so we caught them in bed together.
And not only that, it's a white man and a black man that are together.
In the 90s.
In the 90s.
And also, yeah, on top of that, Eubanks, who called the cops, I'm sure knew how police would respond to a black man in a situation like this. Already very, very dangerous situation. We know the relationship between cops, not only the queer community, but queer people of color, which is just exemplifies it even more. And so, yeah, I'm going to be honest, I don't trust the cops at all in this situation.
The deputies pull both men up and they handcuff them. They're marched through the small rooms and out into the night air. Neighbors can see. A few step out, curious about the commotion. No weapons, no disturbance, just two men in shirt sleeves being hustled into patrol cars. The charge, violation of Section 2106 of the Texas Penal Code, the homosexual conduct law, a statute that makes what happens between consenting adults in private into an offense if those adults are the same sex. A Class C misdemeanor, at least that's the level on paper, a ticketable offense. But it's more than that. It's an arrest record and a mark of criminality that's about sexual identity, not action. Anytime that record came up, such as in a background check for jobs or financial reasons, that person would be clearly marked as a homosexual, marking them for discrimination or worse. Back at the station, the paperwork starts. Officers list the offense. The words alone, homosexual conduct, carry stigma. Booking photos are taken, fingerprints pressed into cards. The bail is small, the men are released that night, and they walk back into a city that, by sunrise, won't know their names yet. But they will. Because there's a problem with this. This wasn't about public lewdness. It wasn't about a gun, because there was no weapon found. In fact, they didn't really even look for a weapon. And the deputies never found one. The only allegation was intimacy. And that intimacy was treated as criminal because of who it involved. John is stunned. He's a private man. Trouble with the law is just not part of his life. Tyrone is younger and black, and he knows the drill a little bit better. He's been through the Harris County system before on unrelated matters. He understands how quickly a small charge can ripple into a larger consequence. They both know how it could cost them their jobs, housing, relationships. Because for queer people in 1998 in Texas, even the whisper of an arrest under Section 2106 could mean everything in your life unraveling. The arrest report makes its way through the Harris County system. It's routine on its face. Deputies logged it as an entry, listed the charge, submitted it up the chain. But the routine is what makes this so damning. This wasn't filed by mistake. It wasn't flagged as unusual. It was just another misdemeanor in the eyes of the state. And this is just two men in a private residence. Even if they were engaged in sexual activity, this is in a private residence. But this is just routine to them. They're like, yeah, they're charged. But lawyers in Houston's LGBTQ plus community didn't see it that way. They had been waiting for this moment for years. Local activists had tracked cases like these, rare but steady. Most defendants took the fine and left. But this time, the circumstances were different. Word spread quickly through the network of the civil rights attorneys. Lambda Legal, a national nonprofit focused on LGBTQ plus litigation, gets the call. This could be the case to finally take on the sodomy laws in Texas, and maybe beyond. They meet with John and Tyron. Both men are wary. The arrest itself was humiliating. It pulled their private lives out into the open. And John, who is very private, is especially reluctant to be the face of a movement. And Tyrone, being black and openly named in a case like this in the late 1990s in Texas, carried dangers far beyond the courtrooms.
Yeah, and you can only imagine, even if you're just the face of the movement, that's a huge target on your back, and people are going to see you as, there's no telling, like, they're going to dox you, they'll harass you, they could try to kill you. Like, I'm sure it's terrifying. I don't know if I'd be able to do it because I'm like, yeah, I mean, it'd be scary just to leave your house at that point, to go anywhere, just to walk to the mailbox. And especially if you are a queer person of color in Texas, that I can't even imagine. It's one of those double-edged swords type situation where it's like, yes, you want to do it because you want the change to happen so this doesn't happen in the future, but at the same time, that's putting your own life at risk. And so, it's a hard place to be, I'm sure.
And that's true, but the lawyers were clear. If they plead guilty, nothing changes. If they fought, they might tear down the law itself. Both men, in the end, reluctantly agree to fight the system. Soon they're arraigned, a misdemeanor docket. Dozens of defendants cycle through, but this case has a different weight. It's not about theft or traffic. It's about the state drawing a line around private lives. In that cramped courtroom, the statute becomes real. The judge reads the charge out loud. Everyone in earshot hears it. 2 men, homosexual conduct. Suddenly, their private knot is not only public, it's public record. Now, this could have ended quickly. Pay the fine, move on. That's what the system expected. That's what most people charged under this law did, because fighting it meant money, time, and exposure. It meant dragging your life out into the spotlight and putting yourself at risk. But John and Tyrone don't plead guilty. They don't even quietly accept no contest. That choice, right there in that courtroom, turns a late-night arrest into something else entirely. A test case. A crack in the armor of a statute that had stood for decades. And although in the end, they were ultimately forced to take no contest pleas and were each fined $200, but this was also part of the plan, as this preserved constitutional challenges for appeal. It's important to pause here, because what deputies claim to see in that apartment, that becomes the foundation of everything that follows. Without that, there's no case. Without that, there's no appeal. Without that, there's no chance to take on Bowers versus Hardwick head on. The so-called crime is bare. Deputies enter, 2 men are arrested, a law is invoked, and that's it. There was no gun, only 2 gay men. With that arrest, the state said that those men's existence is the true offense here. And that is what the lawyers set out to prove. So the lawyers begin an investigation of their own, an investigation that isn't about forensics. It's not about evidence bags or ballistics. It's about the paper trail of Section 2106, the Texas statute at the center of all of this. They look at how many people have been charged. They looked at the patterns, when police actually enforce the law and against whom. The findings line up with what activists have always known. Enforcement is selective. Queer people are targeted, straight couples are left alone. Meanwhile, prosecutors prepare their case. They lean on the deputy's testimony. The officers say they saw the act. That's enough under the statute. No physical evidence is required. No corroborating witnesses are needed. If they've seen it, that's all they need. The defense team pushes back, though. They file motions to dismiss. They argue the law itself is unconstitutional, that it criminalizes private conduct protected by liberty and privacy rights under the U.S. Constitution. But the trial court doesn't bite. The charges stand. And for John and Tyrone, daily life grinds under the weight of the case. Every court date is another public outing of their names. Every news clipping ties them to the phrase homosexual conduct. They can't control the narrative, they can only endure it. And by 1998, the case winds its way up through the appeals system. The 14th Court of Appeals in Texas takes a look. At first, it sides with John and Tyrone. And in 2000, that court strikes down the law, saying it violates equal protection. It's a brief moment of relief. But the state isn't finished. Texas appeals to the full court sitting en banc. Sitting en banc is basically saying this case is big enough that the full panel of judges needs to weigh in, not just a few judges. And in 2001, the court reverses itself. In a 7-2 decision, it reinstates the convictions, and the sodomy law stands. The battle shifts to the Texas Court of Criminal Appeals, the highest criminal court in the state, but the court declines to hear the case. That leaves one final option, the U.S. Supreme Court. And by now, national attention is building. Activist groups see the stakes. If the Supreme Court agrees to take the case, it could revisit Bowers versus Hardwick, the 1986 ruling that gave states the power to criminalize gay sex in the first place. For John and Tyrone, it's a surreal shift. What began as a humiliating arrest in a small apartment is now a vehicle for constitutional law. But their lives are completely consumed by it. They no longer are private citizens. They're plaintiffs in a challenge that would reshape the rights of millions of people. And through it all, the queer community in Houston keeps watch. Activists raise money, lawyers volunteer hours, organizers remind each other of what's at stake here. Because every time someone is arrested under 2106, it reinforces the state's message. Your love is a crime. By late 2002, the petition is in. Lawrence versus Texas makes its way to the docket of the U.S. Supreme Court. It's a direct challenge not only to Texas's law, but to the precedent of Bowers versus Hardwick, the case that for nearly 2 decades has declared that queer people had no constitutional protection for their private lives. When the court agrees to hear it, the stakes couldn't be higher, and civil rights groups recognize what's at play. The American Civil Liberties Union, the Human Rights Campaign, Lambda Legal, all rally around the case. Amicus briefs pour in from legal scholars, medical associations, and even clergy. Even former prosecutors and law enforcement officials submit filings arguing that laws like Section 2106 serve no purpose but to stigmatize. The state of Texas defends the statute, of course. The Attorney General's office frames the law as a moral choice made by legislators. They argue that states have the right to uphold traditional values through criminal codes. And they lean on Bowers, insisting that this is an already settled matter. The Constitution does not protect same-sex intimacy.
It is always fascinating with these cases because, it's like, who are you to decide what is moral? Because 90% of them are probably, I'm sure, do some things that aren't moral behind closed doors. As we get further in the future, you would think cases like this, where it's like, what you do in your own privacy, your own home between consenting adults, it's crazy to think that that's even an issue. But to see it play out, you're like, it's so crazy how big of an issue it becomes.
And don't forget, this isn't like 1950s. This is 2003 at
Yeah.
this point.
And that's what you always say to people like, "Oh, why do we need all these gay pride parades and stuff like this?" Well, it's like, well, just not even 30 years ago, you could be in bed, not even doing anything, just
In your own home,
in your own home, in bed, going to bed after work with your partner of 10 years, and the cops can just come in and arrest you, and they're well within their rights to do so. So it's just crazy to think about, and also a good reminder of, yeah, why we have pride, because stay out of my home.
oral arguments take place on March 26, 2003. The courtroom is packed. Reporters, activists, law students, all waiting to hear whether the justices are willing to reconsider what the court said in 1986. John and Tyrone don't attend. Their lawyers represented them. The men themselves keep their distance from the spectacle. For them, it's never been about attention. It's always been about survival. Paul Smith, the attorney arguing for John and Tyrone, stands before the justices. He frames the case not in abstract terms, but in lived reality of queer people in Texas. The law brands them as criminals. It forces them to live under constant threat of arrest, and it denies them dignity. The questions from the justices revealed divisions. Some pressed the state's lawyer, asking what legitimate interest Texas has in regulating the private sex lives of adults. But others probe whether striking down this law would set a precedent that undermines moral legislation more broadly. Justice Antonin Scalia is openly hostile.
Oh boy, of course he is. I think we all know about good old Scalia.
He warns that if the court overturns sodomy laws, it could unravel bans on same sex marriage, bigamy, even adult incest. To him, the case is a slippery slope. But Justices Sandra Day O'Connor and Anthony Kennedy focus on equality and liberty. O'Connor zeroes in on the fact that the Texas statute applies only to same sex couples. It criminalizes conduct for gay people that is perfectly legal for straight people. And Kennedy looks at the broader principle of privacy. He suggests that what two consenting adults do in their own homes is beyond the reach of the state. The arguments last barely an hour, but in that time, the court hears what queer advocates have been saying for years, that laws like Section 2106 aren't about order or morality. They're about control. 3 months later, on June 26, 2003, the court delivers its opinion. Justice Kennedy authors the majority. In a sweeping 6-3 decision, the court strikes down the Texas statute. It overrules Bowers outright. The language is clear. Adults have the right to engage in private, consensual sexual conduct without government intrusion. To criminalize that conduct, Kennedy writes, is to demean the existence of queer people and control their destiny. The Constitution protects liberty. That liberty includes intimacy. And Justice O'Connor concurs separately. She doesn't go as far as the majority in overturning Bowers, but she agrees that Texas's law violates the Equal Protection Clause by singling out same-sex couples.
And that's the big slope there. I mean, like, I could see it going the opposite way if it included heterosexual couples, but you have no leg to stand on when you're like, oh, well, what if it opens the door to incest and this and this? And it's like, well, it's very clearly, specifically targeting one specific group. So all that could still be happening because this is only affecting this one group. So, you have no leg to stand on, really. And also, it's just so, again, it's so crazy that people are this bothered by what consenting adults do in their own home.
Just like Justice Scalia was, joined by Chief Justice Rehnquist and Justice Clarence Thomas, accuses the majority of signing on to the homosexual agenda. He warns that the decision opens the door to same-sex marriage.
Mm-hmm.
Thomas, for his part, writes that the law is uncommonly silly, but insists that it's not unconstitutional. The ruling reverberates instantly. Lawrence versus Texas doesn't strike down just one state's law. It invalidates all remaining sodomy laws in the country. Overnight, queer people in 13 states are no longer criminals in the eyes of the law for what they do in their private homes. For John Lawrence and Tyron Garner, it's a strange victory. Their names are now etched into constitutional history, but they just returned to normal lives, marked by the scrutiny the case forced upon them. They didn't seek the spotlight. They carried it because the state put them in its glare. And for that moment, the case is more than just a legal win. It's a turning point because the words the court used about liberty, dignity, and the right to define one's own existence become the foundation for battles yet to come. The morning after the ruling, headlines across the country carry the news: Supreme Court strikes down sodomy laws, gay rights landmark. For queer people in Houston, in Texas, and in every state still holding on to those laws, the weight lifted instantly. For the first time, the highest court in the country says their lives are protected, that their existence isn't inherently criminal. It's not full equality, and it doesn't erase discrimination, but it removes one of the most powerful legal weapons ever used against queer people. John Lawrence keeps working at the same hospital. He lives quietly, the way he always had. Tyron Garner returns to his own circle of friends and family, and neither man seeks out interviews or marches. They never wanted to be symbols, yet they become them anyway. Activists, though, know what that decision means. Lawrence versus Texas becomes the cornerstone for every major LGBTQ case that follows. When advocates fight for marriage equality, they point back to Justice Kennedy's words about dignity and autonomy. When challenges to don't ask, don't tell reach the courts, they cite the same language. Even Obergefell versus Hodges in 2015, the case that legalizes same-sex marriage nationwide, rests on the foundation that John and Tyrone built. But the aftermath isn't just legal, it's cultural. For decades, sodomy laws had been the silent justification behind countless forms of discrimination. Employers who fired queer employees, judges who denied custody to queer parents, politicians who claimed homosexuality was synonymous with illegality. All of it leaned on the existence of these laws. With one ruling, that crutch disappeared entirely. And the backlash was real. Conservatives warned of a moral decline, and some states drug their feet, leaving the statutes in the books even though they weren't enforceable. Police in certain jurisdictions continued to threaten arrests, banking on the fear rather than the legality. But over time, the ruling finally sinks in. For Houston's queer community, the case is personal. They know the men at its center. They know the apartment where the deputies burst in. They understand the humiliation John and Tyrone endured. And they understand the courage it took for them to keep fighting instead of just paying a fine and disappearing. John Lawrence passed away in 2011 at 68. His obituary is brief. It doesn't mention the case. And Tyrone Garner passed away even earlier in 2006 at 39. Neither man lived long enough to see marriage equality achieved. Neither become a public figure. But their names remain in every constitutional law textbook, every queer history timeline, and every conversation about dignity and rights for minorities. Lawrence versus Texas is remembered as a pivot. It doesn't end discrimination, it doesn't erase violence, but it tears down the legal wall that said queer lives were inherently criminal. And it proves something deeper, that even a case born out of humiliation and bias can become a vehicle for liberation. Today, when lawyers cite John Lawrence in court, they're not just citing a precedent. They're invoking the lives of two men who never asked to carry the weight of history, but did anyway. And for every queer person who lived under the shadow of those laws, the legacy is this: the right to exist without the state calling your love a crime, the right to dignity, the right to define yourself on your own terms. That's what Lawrence versus Texas gave you. And that's the story of John Lawrence and Tyrone Garner. Who knew that a single phone call, meant to punish would end with a decision that changed the Constitution's promise for millions of queer individuals and led to so many of the rights that we have today.
Most of the time, that's how it happens. It's unintentional domino effects. It's how Stonewall happened. It was just a routine. It wasn't even supposed to happen that night. It was completely random. And it's just little things like that. Like if it didn't happen, if one thing was out of place, if they didn't call, if they left sooner, you know, it's always fascinates me with cases and stuff like this where it's like everything had to fall perfectly in place for it to happen this way. And thankfully, sometimes it has good outcomes and consequences. Case in point. Also, there's still a bit of tragedy to it because it's two people who didn't want to be in the spotlight. They wanted to be private. So, it's like we didn't ask for this, but at the same time, we are thinking about the millions of other queer people out there, and we are giving up our lives, our private lives, to make sure that this doesn't happen to anyone else. And so it's the fact that it just shows you how resilient people are and how much they care about their community at large because that's a tough thing is to give up your own private life for that and to be the face of something like this. I think a lot of people think they want to be a part of history. And, of course, that's an important thing. But at the same time, there's a lot of people that just want to be happy, quiet life
And left alone.
and left alone. And so, it's a tough situation. And thankfully they did it because here we are. And I mean, yeah, we have a lot that we are still dealing with to this day. I don't think I need to go into details about that, but it's a step like this that shows us we are still moving somewhat towards the right direction. And it's small victories and big victories that are going to help us eventually get to one day where we don't have to fight about being any form of queer or honestly any minority. And hopefully I live to see that day. And with that, thank you guys so much for tuning in for another episode. If you enjoyed this episode, please give us a 5-star rating or review on iTunes or Spotify. Helps us out a lot, helps other people discover the podcast. And of course, we just love hearing from you guys. If you want to see photos from today's case, you can follow us on Instagram at Beers with Queers Pod, that's POD, or on Facebook at Beers with Queers, a true crime podcast. And until Monday, stay dangerous out there, my friends.
See you soon.